The sound was not a bang, but a hiss, a sharp, punctuated, and surprisingly intimate sound that cut through the pre-dawn stillness. It was 6:42 in the morning. I know the exact time because I was standing at my kitchen counter, watching the digital clock on the microwave as I waited for my coffee to brew. And the sound made me look up through the bay window that overlooked my front yard and the quiet cul-de-sac beyond. I saw her, Carol. She was kneeling beside the front passenger side tire of my Ford F-150. Her posture was one of intense concentration, her shoulders hunched. In the dim, blue-gray light of early September, I could see the glint of something small and metallic in her hand. Then came another hiss, this one from the rear tire on the same side. She moved with a practiced efficiency that was almost impressive. She didn't look around. She didn't seem to consider the possibility that anyone was watching. In her world, at 6:42 in the morning, she was invisible. She was an instrument of justice, delivering a verdict she had long since passed. In the court of her own mind, I did not move. I did not run to the door. I did not shout through the glass. My heart rate, I noted with a distant sense of clinical curiosity, had barely increased. Instead, I reached for my phone, which was charging on the counter. I tapped the icon for my home security system, the one I had installed myself 3 years ago, after Eleanor passed. The live feed from the camera mounted discreetly under the eaves of the garage filled the screen. The angle was perfect. It captured my entire driveway, the front of my truck, and Carol, the president of our homeowners association, in crisp 1080p resolution. I watched her stand up, a small, triumphant smile playing on her lips. She brushed her hands on her yoga pants, looked at the two rapidly deflating tires with a nod of satisfaction, and then turned and walked briskly back toward her own house 2 doors down. I touched the screen, saving the last 5 minutes of footage to a secure cloud server and also downloading a local copy directly to my phone. I watched it again. The glint of the tool in her hand. It looked like a small ice pick or a sturdy awl. The deliberate way she punctured the sidewalls, not the tread, she knew that made them unrepairable. This was not random vandalism. This was a message. My coffee maker beeped. I poured the dark liquid into a thick ceramic mug, the one Eleanor had given me on my 50th birthday, and took a slow sip. It was hot, bitter, and grounding. I looked out the window again. My truck, a perfectly maintained vehicle with less than 40,000 miles on it, was now crippled in my own driveway. It sat there, listing slightly to one side, a monument to her unshakable sense of entitlement. She thought this was the end of it, the final, decisive act in a long, tedious dispute over a 6-foot-wide strip of grass and a French drain. She thought she was teaching me a lesson, punishing my defiance and restoring the natural order of her little kingdom. She had no idea. She had no idea who I was, what I did for a living for 35 years, or the nature of the beast she had just prodded with a very sharp stick. She had no idea that her petty act of vandalism wasn't an ending, but a key she had just handed me, a key that would unlock a door she didn't even know existed, leading to a room where every single one of her transgressions was neatly filed, catalogued, and waiting. But before I tell you what I did next, I should probably explain how a man like me, a man whose entire life has been dedicated to avoiding drama and adhering to established protocols, found himself in a silent war with the president of his homeowners association. It wasn't a sudden development. It was a slow, creeping infestation, like dry rot in a support beam. You don't notice it at first, and by the time you do, the damage is already structural. My name is Arthur Harris. I am 68 years old, and for 35 of those years, I was a civil engineer for the county's Public Works Department. Specifically, my focus was on water management, infrastructure planning, and easement law. I designed drainage systems. I reviewed subdivision plats to ensure they complied with county and state water runoff regulations. I spent decades reading, interpreting, and enforcing covenants, deeds, and legal descriptions of property. My job was to understand, on a molecular level, what belonged to whom, what rights were attached to a piece of land, and how water was supposed to behave when it rained. It was a quiet job, a job of paper and precision. I liked it that way. My wife Eleanor and I bought this house 30 years ago. We were the second owners. The subdivision was only a few years old then, carved out of an old farm. I remember reviewing the initial plat maps for this development when they first came across my desk at the county office. I knew its bones. I knew where the utility easements were buried, how the storm sewers were routed, and the exact legally recorded boundaries of every single lot. When we bought our house at the end of the cul-de-sac, I did my due diligence. I had a full survey done. I read our deed, the title report, and the HOA's founding documents, the covenants, conditions, and restrictions, or CC and ORs, from cover to cover. I knew precisely what I was buying, a quarter acre of peace and quiet. For 28 years, that's exactly what it was. The HOA was a sleepy, barely there entity. We paid our $100 a year, and they paid someone to mow the small patch of grass by the subdivision's entrance sign. No one bothered anyone. We lived, we worked, we raised our kids. It was peaceful. Then Eleanor got sick, and for 2 years the world outside this house barely registered. After she was gone, the quiet of the house was different. It was heavier. I retired a few months later, seeking to preserve what little peace I had left. That's when Carol happened. She and her husband moved in about 5 years ago, but it was 2 years ago, at an HOA meeting I didn't attend, that she was elected president. Her platform, as I later heard it, was restoring community standards and protecting property values. This, in practice, translated to a reign of meticulously documented terror. Carol was a performer. She had the kind of aggressive, chipper energy that some people mistake for leadership. She was in her late 40s, always dressed in expensive athletic wear, and she walked the neighborhood every morning with a clipboard. At first, the notices were minor. Mr. Henderson, my neighbor to the left, a widower in his 80s, was fined $25 because his garden hose wasn't coiled neatly enough. The family across the street was fined $50 because their son's bicycle was left on the lawn. Overnight, the infractions were real, technically. The CC and Rs did have vague language about keeping properties neat and tidy, but the enforcement was new, it was aggressive, and it was personal. I stayed out of it. I kept my lawn immaculate. My trash cans were brought in the moment the truck had passed. I was a ghost. My first direct interaction with her came about 18 months ago. It was about the drain. My property, being at the bottom of the cul-de-sac, had always had a small issue with water pooling in the front yard. After a heavy rain, it was a flaw in the original grading of the subdivision, something I had noted in my head 30 years prior, but never bothered to fix. After I retired, I had time. I designed a simple, effective French drain. It ran along the edge of my property, caught the runoff from my yard and the street, and channeled it harmlessly toward the storm sewer inlet at the curb. It was a 2-day project. I dug the trench, laid the perforated pipe, filled it with gravel, and covered it with sod. It was invisible. It was also entirely on my property. The edge of the drain was a good 2 feet inside my property line, which was marked by a small iron survey stake I had located with my own transit the day we moved in. A week after I finished the project, the first letter arrived. It was a formal notice of violation from the HOA, unapproved modification to a common area, it read. It demanded I immediately restore the common area grass strip to its original condition, and included a $100 fine. I knew exactly what she was talking about. There was a 6-foot strip of land between the curb and my official property line. This is common in many subdivisions. Sometimes it's a utility easement owned by the county. Sometimes it's designated as a common area owned by the HOA. And sometimes, as in the case of our subdivision, it is part of the privately owned lot, but burdened by a public utility and access easement. On paper, that strip of land was mine. I owned it. The county had the right to dig it up to service the water lines, but it belonged to me. The HOA had no claim to it whatsoever. My first instinct was to write a letter, to explain the situation with diagrams and copies of the plat map. But then I thought about Carol. I had seen her in action. I had seen her shout down Mr. Henderson at his own front door over the placement of a decorative flamingo. She wasn't interested in facts. She was interested in power. Arguing with her would be like playing chess with a pigeon. It would knock over the pieces, defecate on the board, and strut around like it won. So I did something else. I started a file. It was a simple manila folder. On the tab, I wrote HOA correspondence. Inside, I placed her letter. Then, I wrote a check for $100, put fine for unapproved modification in the memo line, and made a photocopy of it before mailing it. I stapled the photocopy to the letter. This was the first entry. I was creating a paper trail. I was paying a fine for something that happened on my own property, and the canceled check would be the HOA's signed confession that they had accepted payment for it. On paper, they were asserting jurisdiction over my land, and I was quietly letting them. A month later, another letter. Another $100 fine for the same infraction. I repeated the process. I paid it. I photocopied the check. I filed it away. This went on for 3 months. I now had 3 letters and 3 canceled checks. Then she escalated. She started sending letters about my truck. According to a rule she had apparently invented, commercial-style vehicles were not allowed to be parked in driveways. My F-150, which I had owned for 10 years and used for trips to the hardware store, was now a commercial vehicle. The fines started at $50 and went up each month. I paid them. I kept the receipts. The folder grew thicker. I knew this was a war of attrition. She expected me to argue, to get angry, to fight back in a way that would make me look like the unreasonable one. She wanted a shouting match. She wanted to perform her authority for the neighbors. I gave her nothing. I gave her only checks and silence. In the meantime, I observed. I watched her fine the young couple for having a political sign in their yard 2 days after the election. I watched her measure the height of Mr. Henderson's sunflowers with a tape measure and write him a citation because they were over the 6-foot limit she had decreed at the last meeting. I kept the receipts of my own quiet protest, and I mentally filed away hers. The drain, however, remained her primary obsession. After 6 months of my silent compliance, she must have grown bored. The letters stopped. But I would see her standing on the sidewalk, staring at that invisible line in my lawn, where the drain lay buried. It was a symbol of my defiance, a quiet, functional rebellion that she couldn't see but knew was there. It worked perfectly, and my yard was the only one on the cul-de-sac that didn't have a small pond in it after a thunderstorm. That, I think, is what truly bothered her. It worked. This brings me to the week before the tire incident. We had a massive storm, a 100-year rain event, the kind of thing I used to model on computer systems. 3 inches of rain in 2 hours. The street flooded. Water was halfway up the driveways of every house except mine. My French drain, working exactly as designed, was a silent, gurgling vortex protecting my property. Carol's house, which was on higher ground but still affected by the overwhelmed storm sewers, had water lapping at her garage door. The next morning, as the water receded, the new notice was taped to my door. It was a final demand. It stated that my illegal drainage system had diverted an unnatural volume of water and contributed to the flooding of other properties. It demanded I remove the drain within 7 days, or face a $5,000 fine and a lien against my property. This was a new level. A lien was a serious legal threat. It was also, from an engineering and legal standpoint, complete and utter nonsense. My drain was lowering the total volume of surface runoff, not increasing it. It was helping the overwhelmed county system, not harming it. But she wasn't dealing in facts. She was dealing in blame. It was time to move from passive documentation to active resolution. On Monday, I drafted a formal letter. I typed it on my old letterhead from my consulting business, which made it look official. In clear, simple terms, I explained that the drain was located entirely on my private property, as defined by the official plat map for the subdivision, file number 84-C, page 112, in the county records office. I attached a copy of my survey with the property lines and the location of the drain clearly marked. I explained that the drain improved, rather than harmed, the overall water management of the cul-de-sac, and cited the relevant county codes regarding homeowner responsibility for surface water runoff. I was polite, professional, and firm. I stated that the HOA had no jurisdiction in the matter, that their threats of fines and a lien were baseless, and that I considered the matter closed. I sent the letter via certified mail, with return receipt requested. I wanted a signature. I wanted proof that she had received it. The little green card came back a few days later, signed in Carol's loopy, arrogant script. I taped it to my copy of the letter and placed it in the folder. I also had my security camera aimed at her front door. The footage of the mailman handing her the envelope, her signing for it, and then, after he left, her looking at the return address and tossing the unopened envelope directly into her recycling bin, was saved in a separate file on my computer labeled Evidence. That was on a Thursday. For 5 days there was silence. I thought, perhaps foolishly, that the formality of the letter, the sheer weight of the facts it contained, might have given her pause. I thought she might have at least consulted a lawyer who would have told her she was standing on thin ice over a legal abyss. I was wrong. She wasn't consulting lawyers. She was sharpening an ice pick. The attack on my tires was her response. It was her answer to my carefully drafted letter, my survey map, my citation of county code. It was a primal scream of, "I don't care about your facts." And so, as I stood in my kitchen, sipping my coffee and looking at my wounded truck, I felt a strange sense of calm, the kind of calm that comes when the parameters of a problem are finally, irrevocably defined. She had taken a civil disagreement about rules and regulations and turned it into a criminal matter. She had taken it off paper and made it physical. She had no idea how much of a mistake that was. Because on paper is where I live. On paper is where I am invincible. I finished my coffee. I went to my study, a room lined with books on engineering, law, and history. I sat down at my large oak desk, the one I'd had for 40 years. I pulled out the manila folder, now thick with a year and a half of her misguided provocations. I placed it squarely in the center of my desk blotter. Then, I swiveled in my chair and turned on my computer. It was time to get to work. My first call was not to a lawyer. It was to Maria. Maria had been my research assistant at the county for the last 10 years of my career. She was technically a paralegal, but she was more of a bloodhound. If a document existed anywhere in the county, state, or federal archives, Maria could find it. She had retired a year after I did, but we kept in touch. I knew she did freelance work from home. Arthur. Her voice was as cheerful as ever. To what do I owe the pleasure? Don't tell me you're finally building that deck and need me to look up the setback codes. Something a little more involved than that, Maria, I said. I have a project for you. I need you to do a deep dive on a homeowners association. I explained the situation in concise, factual terms. I didn't mention the tires. I framed it as a legal and administrative query. I gave her the HOA's official name, the Oaks at Meadow Lane Homeowners Association, Inc. I asked her to find everything. The original articles of incorporation, the bylaws, all filed amendments, all annual reports filed with the Secretary of State. I wanted to see the chain of custody for its leadership, the minutes from every meeting she could find, and, most importantly, its current legal standing as a corporation in the state. "So, you're finally fighting back against the HOA Dragon Lady," she said with a laugh. She had heard stories from me over our weekly coffee meetings. "I thought you were just going to let her fine you into oblivion." "The situation has evolved," I said. "I'll pay your standard rate, of course. I want this to be official. Document all your hours. Keep the receipts." You got it, Arthur. This sounds fun. I'll see what skeletons I can dig up. She promised to have a preliminary report for me within 48 hours. My next step was to deal with the immediate problem, the truck. I called my insurance company. I explained that my vehicle had been vandalized and was currently disabled. I was careful with my words. I said I had reason to believe I knew who the perpetrator was and that I had video evidence, which I would be providing to the police. They were very helpful. They opened a claim, told me a claims adjuster would be in touch, and arranged for a tow truck to take my F-150 to a certified repair shop. They also arranged for a rental car to be delivered to my house that afternoon. My third call was to the non-emergency line of the local police department. I calmly explained that I needed to file a report for destruction of property. I gave the dispatcher my name, address, and the time of the incident. I mentioned that I had clear video footage of the act being committed. This detail seemed to change the tenor of the call. I was given a case number and told a detective from the Property Crimes Division would contact me within a day. With the immediate logistics handled, I turned back to the larger strategic picture. Carol's power rested on three pillars: the perceived authority of the HOA, the ignorance of the residents about their actual rights, and the fear of legal and financial repercussions she cultivated. My goal was to dismantle all three. I spent the rest of the day in my study. I took every document from the manila folder and scanned it, creating a high-resolution PDF of each letter, each canceled check, each certified mail receipt. I created a timeline, a spreadsheet that detailed every interaction, every fine, every piece of correspondence, with dates, amounts, and a reference to the corresponding document. It was a dry, methodical task, and it was deeply comforting. This was my world. I was taking her chaotic, emotional aggression and reducing it to a set of data points. While I worked, I thought about my neighbors. I thought about Mr. Henderson and his garden gnomes. I thought about the family with the basketball hoop. Carol's power wasn't just about the rules. It was about isolating her targets. She picked on people she knew were unlikely to fight back. The elderly, the young families who were too busy, the people who just wanted to be left alone. She created an atmosphere where complaining felt like you were the one causing trouble. The rental car, a bland silver sedan, arrived late that afternoon. The tow truck came shortly after and hauled my wounded F-150 away. I watched from the window as it was loaded onto the flatbed. I saw Carol watching from her own window, a flicker of movement behind the curtains. I could almost feel her smug satisfaction radiating across the cul-de-sac. Let her feel that way, I thought. Confidence is the currency of the unprepared. The next morning I received a call from Maria. Her tone was different. It wasn't the cheerful, treasure-hunting voice from the day before. It was quiet, almost reverent. "Arthur," she said, "you are not going to believe this." "Try me," I said, leaning forward in my chair. I pulled the corporate filings from the Secretary of State's office. The Oaks at Meadow Lane Homeowners Association Incorporated was chartered 34 years ago, as expected. They filed their annual reports like clockwork for 32 years. She paused for dramatic effect. I waited. "Arthur," she said, her voice dropping to a whisper, "they haven't filed a report or paid their registration fee in 2 years. Their corporate status was administratively dissolved by the state 18 months ago for failure to file." I was silent for a moment, letting the information sink in. I felt a slow, cold wave of vindication wash over me. It wasn't triumph. It was the quiet click of a final puzzle piece sliding into place. "Maria," I said slowly, "are you telling me the HOA does not legally exist?" "That's exactly what I'm telling you. On paper, as of 18 months ago, this HOA is a ghost. It's a defunct corporation. It has no legal authority to do anything. It cannot enter into contracts, it cannot enforce covenants, and it most certainly cannot levy fines or place lines on property." She had no idea. Carol, in her relentless pursuit of absolute power over lawn ornaments and pickup trucks, had neglected the one, simple, bureaucratic task that gave her any power at all. She had failed to file a 2-page form and pay a $50 fee, and in doing so, she had rendered her entire regime a fraud. "Maria," I said, my voice steady, "can you get me a certified copy of that dissolution notice from the state?" "It's already on its way. I overnighted it. You'll have it tomorrow morning." This was the bombshell. This was the foundation of her entire kingdom, turning to sand. Every fine she had levied for the past year and a half-ish, every threatening letter, every bit of fear she had instilled in my neighbors, it was all based on a lie. She wasn't the president of an HOA. She was just a woman with a clipboard and a whole lot of nerve. I kept the receipts. Now I had the one that mattered most. The next day, as promised, the certified document from the Secretary of State arrived. I held it in my hands. It was a simple, bureaucratic form, full of boilerplate legal language. But to me, it was a masterpiece. It was the Archimedean lever with which I could move Carol's world. But I didn't act on it immediately. A weapon this powerful had to be deployed at the right time, in the right way. A quiet revelation is not nearly as effective as a public one. Carol's power was performative. Her downfall had to be as well. The opportunity presented itself 2 days later. Carol, emboldened by my crippled truck being gone and my subsequent silence, decided to press her advantage. She saw the rental car in my driveway and must have assumed I was beaten, forced to rent a car because I couldn't afford to fix my own. Her mind would naturally leap to the most condescending conclusion possible. That afternoon, a new notice was taped to my door. This one was printed on bright red paper. It was a towing warning. It stated that the inoperable vehicle, my F-150, had not been removed, and that, if it was not gone within 24 hours, the HOA would have it towed at my expense. The fact that the truck was already gone, that it had been gone for 2 days, was a detail that had clearly escaped her notice. She was operating on pure, unadulterated self-righteousness. But then she did something truly foolish. She must have seen me drive up in the rental sedan. A few hours later, I heard a commotion outside. I looked out the window. Carol was standing in the street, directing a large tow truck as it backed up toward my driveway. She was pointing at the rental car. She was going to have my rental car towed from my own driveway, presumably under the theory that it was a replacement for the inoperable vehicle she had already ordered removed. The tow truck driver, a large man with a weary expression, looked hesitant. He was pointing at the car, then at the house. Carol was gesturing emphatically, her voice carrying across the lawn. "It's an unauthorized vehicle on association property. I am the president, and I am authorizing you to remove it." This was the moment, the public confrontation she had always wanted, but on my terms, with an official audience. I picked up my phone and dialed 911. 911, what is your emergency? "I'd like to report a vehicle theft in progress at 112 Meadow Lane," I said calmly. "A woman is attempting to have my rental car illegally towed from my private driveway." I gave the dispatcher the details. I was calm. I was precise. I mentioned that the woman was falsely representing herself as having authority over my property. I stayed on the line until they confirmed that a unit was on its way. Then I walked outside. I didn't run. I walked. I held 3 things in my hand: my driver's license, the rental agreement for the sedan, and a folded 11 by 17 copy of my property survey map. When Carol saw me, her face lit up with a predatory glee. "Well, well, look who finally decided to come out," she crowed, loud enough for the tow truck driver and any watching neighbors to hear. "Your 24 hours are up, Arthur. I'm having this junker removed." "This is a rental car," I said, my voice even. "It is legally parked in my private driveway. You have no authority here." "Your driveway is part of the common area aesthetic," she snapped. "It's in the rules. I am the president of the Homeowners Association, and I am ordering this vehicle removed." The tow truck driver looked from her to me, his expression souring. "Ma'am, is this his private property?" "It's complicated," she said dismissively. "Just do your job. We'll pay you." Just then, a police cruiser turned into the cul-de-sac and pulled up behind the tow truck. A young, fit-looking officer got out. His name tag read Jennings. He had that look of crisp professionalism that rookie cops have before the job wears them down. "What's going on here?" he asked, his eyes scanning the scene. Carol, puffed up with indignation. Me, standing calmly by my front walk. The tow truck driver, looking like he wished he were anywhere else. Carol immediately launched into her performance. "Thank goodness you're here, officer. This man," she said, pointing a trembling finger at me, "is a constant source of trouble in this community. He refuses to follow the rules. The HOA has ordered his inoperable vehicle removed, and he's trying to obstruct us." Officer Jennings turned to me. "Sir, is this your vehicle?" "No, officer," I said. I held out the rental agreement. "This is a rental car, rented in my name. This is the agreement. It is parked in my driveway, on my private property." I then unfolded the survey map. It was large and official-looking, covered in lines and surveyor's marks. I pointed to the clear, dark line that separated my lot from the street. "As you can see from the official county plat map, my property extends from the house all the way to this point," I said, pointing to the iron survey stake near the curb, which is 5 feet beyond the edge of the sidewalk. "The car is parked a good 10 feet inside my property line. This woman has no legal right to be on my property, let alone to have my vehicle towed from it." The officer took the map and looked at it. He was a smart kid. He understood what he was seeing. He looked at the survey stake in the ground, then back at the map, then at the car. He then turned to Carol. "Ma'am," he said, his tone shifting from inquisitive to firm, "you are attempting to have a vehicle removed from private property. That's a civil matter at best. If you don't have a court order, you can't do that." "I am the president of the HOA," she shrieked, her voice cracking. "We have bylaws. He is in violation." "That may be," the officer said patiently, "but the HOA is a civil organization. It is not a law enforcement body. You are, in effect, trying to steal this man's car. I would advise you and this tow truck driver to leave the premises immediately." He then looked at me. "Sir, do you wish to press charges for trespassing?" This was the beautiful part. I could have. But that would have been a small victory. I was playing a much larger game. "No, officer," I said. "However, I would like to make a formal statement for your record. I want it noted in your report that this woman, Carol Peterson, representing herself as the president of the Oaks at Meadow Lane Homeowners Association, did attempt to have my vehicle illegally removed from my private property, located at 112 Meadow Lane. I would also like to note for the record that I have informed her in writing that her organization has no jurisdiction here. I was creating a new document, a police report that established her actions, and my formal, on-the-record refutation of her authority." His body camera was recording every word. Officer Jennings nodded slowly, his eyes fixed on Carol. "I've got all that on camera, sir." He turned to her. Her face had gone from red to a pasty white. The tow truck driver was already back in his cab, starting the engine. "Ma'am, I am giving you a formal warning for trespassing. Do not come back on this property. Is that understood?" She just stared at him, her mouth opening and closing silently. She looked utterly defeated. The tow truck pulled away. Carol, without another word, turned and scurried back to her house. "Thank you for your time, officer," I said to Jennings. He gave me a small, almost imperceptible nod. "Get a new set of tires on that truck of yours, sir," he said quietly, a hint of a smile in his eyes. He knew. He didn't know how he knew, but he knew. "Have a good day." As I walked back into my house, I saw a curtain twitch in Mr. Henderson's window. He had seen the whole thing. The performance was not just for the police. It was for the entire neighborhood. I had publicly stood up to her, and I had won. Not with shouting, but with paper. An hour later, my doorbell rang. It was Mr. Henderson. He was holding a small, worn shoebox. He looked nervous, but there was a spark of something new in his eyes. "Hope." "Arthur," he said, his voice a little shaky. "I saw what you did. That was incredible." "She left me no choice, Robert," I said, inviting him in. He sat down at my kitchen table and pushed the shoebox toward me. "I've been keeping these for years," he said. "Every notice, every fine she ever gave me, for the gnomes, for the hose, for the bird feeder she said was attracting nuisance birds." He opened the box. It was crammed with letters, just like my own folder. "I always just paid. It was easier. I didn't want the trouble." "I understand," I said. "But that's not all," he said, reaching into his pocket. He pulled out his smartphone. He fumbled with it for a moment, then played an audio file. The quality was poor, muffled, but the voice was unmistakable. It was Carol, speaking, at what sounded like a board meeting. "Look, David, I don't care what the original bylaws say." Her voice crackled from the small speaker. "They're 30 years old. This is a different community now. It doesn't matter what the old papers say. We decide what the rules are now. If they don't like it, they can move." I stared at the phone. "When was this recorded, Robert?" "About a year ago," he said. "I went to the meeting to protest the fine for my sunflowers. She had me thrown out, but I had my phone recording in my pocket. I saved it, and I don't know why." "You saved it because it's evidence, Robert," I said, a grim satisfaction settling over me. "It's evidence of her willful intent to disregard the governing documents of the organization she purports to lead." I looked at this frail, elderly man who had been bullied for years. He had just handed me the sword. The certified document from the state was the legal reality. This audio recording was her confession. That evening I made another call. To David Miller. David was a lawyer, a young guy who did corporate law downtown, and he was the treasurer on the HOA board. I had seen him argue with Carol in meetings before, always trying to inject a note of reason, and always getting shut down. He was the David from Robert's recording. I laid out the situation for him, minus the bombshell about the corporate dissolution. I told him about the tires, the police report, and Robert's audio recording. I could hear him sigh heavily over the phone. "I'm not surprised, Arthur," he said. "It's been getting worse. She makes decisions unilaterally. She doesn't consult the board. She uses the HOA funds to pay a lawyer who's a personal friend of hers to send threatening letters. I've tried to tell her she's exposing us to massive liability, but she doesn't listen." "David," I said, "I'm preparing to take formal legal action. But I wanted to give you a chance to be on the right side of this. The other board members have allowed her to do this. On paper, you are all complicit." There was a long silence on the other end of the line. "What do you need?" he finally asked. "I need your testimony," I said. "I need a copy of the HOA's financial statements for the last 2 years. And I need to know the name of the lawyer she's been using." "I can do that," he said, his voice firm. "It has to stop. I'll email you the documents tonight." The coalition was forming. The fearful ally and the disillusioned insider had come forward. The pillars of her power were beginning to crumble. The final piece of the puzzle arrived, as I knew it would, the very next day. It was a letter delivered by a process server. Carol had made her final, desperate move. She had her lawyer file for an emergency temporary restraining order against me. The petition was a work of fiction. It claimed I was stalking her, harassing her, and that she was in imminent fear for her life. It painted me as a menacing, unstable recluse. It was her last, pathetic attempt to use the system she disdained to silence the man who was using it to dismantle her. A hearing was set for the following week. In a courtroom, in front of a judge. She had no idea what a gift she had just given me. She had, at her own expense, provided the perfect stage for the final act. I called a lawyer, not just any lawyer, but the best litigation attorney in the city, a man named Marcus Thorne, whose firm I had worked with on complex county easement disputes for years. I sent him my entire digital file, the scans, the timeline, the video of the tire slashing, the police body cam footage I had requested a copy of, Robert's audio recording, David's internal emails, and the certified document from the Secretary of State. There was a long pause after I finished explaining everything. "Arthur," Marcus said, and I could hear the grin in his voice, This is the most beautiful case I've ever seen. It's a perfectly constructed legal cage. We're not just going to get this restraining order thrown out. We're going to get it thrown out with extreme prejudice. And we're going to ask the judge to refer her to the district attorney's office for perjury and criminal vandalism, and her attorney to the state bar for filing a frivolous lawsuit on behalf of a non-existent corporate entity. That sounds acceptable, I said. The day of the hearing arrived. The courtroom was small and smelled of stale coffee and anxiety. Carol was there with her lawyer, a slick-looking man in a suit that was a size too tight. She had assembled a small, cheering section of her bored cronies and sycophantic neighbors. They sat behind her, whispering and casting venomous looks in my direction. Carol herself looked serene, confident. She was dressed in a conservative navy blue suit, a pearl necklace at her throat. She was playing the part of the respectable victim. On my side, I had Marcus, of course, and sitting in the gallery behind me were Robert Henderson and David Miller. They had both agreed to testify if needed. The judge, a weary-looking woman named Espinoza, called the case. Carol's lawyer began. He laid out her fabricated story of my menacing behavior. He showed photos he claimed were of me surveilling Carol's house. They were photos of me on my own front porch, drinking coffee. Then Carol took the stand. It was the performance of a lifetime. Her voice trembled. Tears welled in her eyes as she described her fear. She spoke of my unprovoked aggression and my disturbing obsession with her. She was believable. If I hadn't known the truth, I might have even felt sorry for her. When it was Marcus's turn to cross-examine, the atmosphere in the room shifted. He was calm, almost gentle. "Mrs. Peterson," he began, "you've testified that you are in fear of my client, Mr. Harris? Is that correct?" "Yes," she whispered, dabbing her eye with a tissue. "Terribly. And this fear stems from his harassment of you, which you claim has been ongoing?" "Yes, for months." "Is it your testimony, then, that you have been avoiding all contact with Mr. Harris?" "I've tried to," she said. "But he's always there." Marcus walked back to our table and picked up a tablet. "Your Honor, I'd like to play a short video clip. This is from Mr. Harris's home security camera, dated September 12th of this year, at 6:42 a.m. He projected the video onto the large screen in the courtroom. It was the footage of Carol kneeling by my truck, the glint of the ice pick, the hiss of the tires, the little smile of satisfaction. A collective gasp went through the courtroom. Carol's face, which had been a mask of sorrowful victimhood, went utterly blank. Her lawyer jumped to his feet. "Objection! Relevance!" "Overruled," Judge Espinoza said, her eyes glued to the screen. "It is highly relevant to the witness's credibility. Please continue, Mr. Thorne." Marcus turned back to Carol. Her serene composure was gone. A flush was creeping up her neck. "Mrs. Peterson," Marcus said, his voice like ice, "is that you in the video?" She stared at the screen, speechless. "Is that you, Mrs. Peterson, on my client's private property at 6:42 in the morning, systematically destroying his tires?" I was," she stammered. "Let's move on," Marcus said, not waiting for an answer. "You've stated that you are the president of the Oaks at Meadow Lane Homeowners Association, and that your actions have all been in your official capacity, correct?" "Yes," she said, grabbing onto the lifeline. "I was acting on behalf of the HOA." "And the HOA has rules, bylaws that you are sworn to uphold?" "Yes, of course." "Your Honor," Marcus said, "I'd like to play a brief audio clip." He played Robert's recording. The sound of Carol's voice filled the silent courtroom. "It doesn't matter what the old papers say. We decide what the rules are now." Judge Espinoza leaned forward, her expression hardening. Carol's lawyer was slowly sinking in his chair. "Mrs. Peterson," Marcus continued, "is it your position that you are above the written bylaws of your own organization?" "No, that's out of context," she insisted, her voice rising in panic. "Finally, Mrs. Peterson," Marcus said, walking to the clerk and handing her a document. You filed this petition as Carol Peterson, president of the Oaks at Meadow Lane HOA Inc. Sheriff. Is that correct? Yes. Your Honor, Marcus said, turning to the judge, I am entering into evidence Exhibit C. This is a certified document from the Secretary of State's office. It shows that the corporate charter for the Oaks at Meadow Lane Homeowners Association Inc. was administratively dissolved 18 months ago for failure to file annual reports. He let the words hang in the air. The silence in the courtroom was absolute. Carol's lawyer looked at the document, his face turning the color of ash. He knew he had filed a suit on behalf of a client that did not legally exist. Marcus turned to face the judge. Your Honor, not only is this petition for a restraining order a complete fabrication, backed by perjured testimony, and designed to harass my client, but it has been filed by a plaintiff, the HOA, that is a legal ghost. Mrs. Peterson has been operating a defunct corporation for a year and a half, illegally extracting fines and terrorizing residents with no authority whatsoever. We ask that you dismiss this TRO with prejudice and that you refer Mrs. Peterson to the district attorney for criminal prosecution on charges of perjury and felony vandalism, and that you refer her counsel, Mr. Davies, to the state bar for professional misconduct. Judge Espinoza looked from the state document to the video still frozen on the screen, to Carol's face, which was now a mask of pure, unadulterated shock. The collapse was total. The performer had run out of script. She sat there, motionless, as the entire architecture of her reality was dismantled, brick by brick, in front of a captive audience. The judge's gavel came down with a crack that echoed in the silent room. Petition dismissed with prejudice, she said, her voice cold as steel, and I will be taking Mr. Thorne's recommendations under advisement. The district attorney and the state bar will be hearing from my office this afternoon. We are adjourned. The aftermath was swift and brutal. Carol was charged with felony destruction of property. Faced with the high-definition video evidence, she had no choice but to plead guilty. She received 2 years of probation, a court order to pay for the full replacement of my 4 tires. I insisted on a new matching set, and restitution for my legal fees. Marcus was not cheap. But that was just the beginning. The revelation that the HOA was defunct sent a shockwave through the neighborhood. David Miller, with my help, organized a community meeting. We explained the situation to our neighbors. The anger was palpable. For 18 months, they had been living under the thumb of a phantom government. Marcus Thorne, on behalf of a class of 22 homeowners, filed a civil suit against Carol personally. The suit sought the full repayment of every fine she had collected since the date the corporate charter had expired. The total was staggering. With interest and punitive damages, the court awarded the plaintiffs, my neighbors, a judgment of over $40,000. Robert Henderson alone got back nearly $2,000 for his gnomes and sunflowers. Carol and her husband were ruined. The legal fees, the criminal fines, and the civil judgment forced them to sell their house to cover the debt. The day the for sale sign went up on our lawn was a quiet day of celebration on our cul-de-sac. We, the residents, did the proper thing. We legally reincorporated the HOA. We elected a new board. David Miller is the new president. Robert Henderson is the vice president, in charge of the new Architectural Review Committee, which was his idea. Its only rule is that you have to be nice. We passed a new set of bylaws, which I helped draft. They are simple, reasonable, and almost impossible to use for personal vendettas. Our annual dues are $50, and they are used to mow the front entrance and host a neighborhood barbecue every summer. My truck was repaired, good as new. The insurance company, after receiving a copy of Carol's guilty plea, waived my deductible and went after her for their costs. It was a clean, satisfying process. Sometimes I sit on my front porch, in the same spot where Carol's lawyer took the photos of me, stalking her. I drink my coffee and look out at the quiet street. The houses are neat. The lawns are mowed. Mr. Henderson's gnomes are back, and there are more of them now. The kids' basketball hoop stays out some nights, and nobody cares. It's peaceful. It's the kind of peace that comes not from an absence of rules, but from the presence of just and reasonable ones. My manila folder, the one labeled HOA correspondence, sits on a shelf in my study. It's thick now, filled not just with her threats, but with copies of court orders, settlement agreements, and a thank you card, signed by 22 of my neighbors. It's a tangible object, a record, a testament to the simple, powerful idea that truth, when patiently documented, is the most effective weapon there is. On paper, she never stood a chance. She just had no idea what the paper said. And she never bothered to read it.